Musical chairs.
Any of those are good?
Yes, there's one seat right here. You just have to sit next to Martin.
I know this fellow. We're supposed to.
Hi, Latif.
Hey, how you doing? Not bad, not bad. How are you?
Okay.
Yeah. What are you up to these days?
We're planning for a big conference, so it's just busy time, you know. Yeah. 16,000 librarians. And they're coming to DC. We're gonna have a
We can flush.
Well, I'll have to come take a look. How are you? How you doing? Good to see you. Everything good? Yes. Good.
Yeah, I will see you on Saturday.
Oh, yeah, that's right, for our session.
That's good.
Oh, awesome, okay, great.
It's right over there. Is it for librarians only or?
Librarians, vendors, there's a lot of vendors, library trustees,
I see.
public company.
Well, include me on your note list and this way, this way when I know when there's like a tremor in the force that week.
Yeah,
I'll know it's because they're librarians.
there's a bunch of librarians all over the place. You'll see them, they'll show up places.
That's right. And they'll all be carrying books.
Big bag of stuff, all the freebies, we gotta get that.
That's right.
Don't you stop.
That's right.
We expect it.
I can understand.
My parents were so proud of me, not speaking their native languages,
You must be head down in the writing somewhere. As always.
I really don't.
Yeah, it's been a while. I guess I haven't seen you since you. It's been a while. I'm fine.
Who's going to do the?
I don't know.
Okay, yeah.
Maybe Sarah.
You need a clicker operator? Martin, that's very good. Running his slides. Did you want me to run the slides for you? This is for show. Oh, right, very good. So that nobody sat here, because I want you as the moderator to see what's happening.
Oh, that's fabulous. Good. Oh, that was
Whoever
very
talks, you'll explain it to them.
This is brilliant. Yeah, there's a save now.
Yeah. Brilliant. Do you need anything else? I think we're. Thank you, everyone. I'd like to welcome you to the Microsoft Innovation and Policy Center. My name is Susan Mann, and I lead Microsoft's IP-focused work here in Washington, D.C. I'd like to thank Professors Carroll and Flynn for the opportunity to partner with Washington College of Law and the Project on Information Justice and Intellectual Property, and bring together so many great friends and colleagues this afternoon, and also in welcoming our distinguished speaker. We're looking forward to your presentation. I'm an AU grad, so this is a very proud moment for me. It's also a bit of fun too. I think I've worked for Microsoft 17 years. This is the first time I've had a glass of wine in this country. So it's quite a happy occasion. So with that, I'll turn it over to Mike to do the introductions. But really, we're so grateful to all of you for being here, for everyone who's joining us remotely. Thank you very much for making time, and we look forward to a very productive and interesting discussion.
Great. Thank you, everyone. It's so nice to see so many familiar faces all together in this space. And thank you, Susan, for hosting us. It's great. We've, over the past few years, we've developed a really nice working relationship with Susan and Microsoft. They host an annual alumni networking event for us in the fall that's been fantastic. And then some of the policy discussions I've had a chance to come down and participate in and learned a lot. And it's been great. And so bringing scholars and researchers together with people active in the policy discussion, I think is productive, and I'm very much looking forward to Martin's views. The setting, I think, as we all know, is at the turn of the millennium, there were discussions about the rules for the so-called information superhighway. And we had the Digital Millennium Copyright Act in the United States that laid out a sort of a deal in which technological protection measures were being offered to content providers, aimed for limitations on liability for platforms and service providers. And Europe quickly followed suit with the e-commerce directive, with the goal that there be some uniformity across transatlantic uniformity as a goal, as a policy goal. That's changed. Europe has taken a different direction. And we now, the member states will be left to implement this new directive, the Digital Single Market Directive, that imposes a series of new obligations on service providers. And Martin has some interesting ideas about exactly what those obligations are and how there are opportunities maybe to bring more flexibility into the national implementation. So I'm thrilled to hear about that, and we'll also have discussion about, is this a model? Is this the turning point where we give up on the vision at the turn of the millennium, or is this just one part of the conversation that is not necessarily going to dominate the rest of the conversation? So Martin, please tell us more.
Yeah, well, thank you so much. You organizers, of course, the PGIP team and Microsoft for bringing this event together. It's really an honor to be here and have the chance of speaking about the EU reform agenda. So my focus is on user-generated content and the new, as Michael already said, the new regulation of liability and obligations in the field of online platforms, in particular content sharing platforms. That's only one piece of the whole reform agenda. And I think it's fair to say that this Digital Single Market Directive in the field of EU copyright law is really the second milestone after the Information Society Directive that was adopted in 2001. So there are so many new aspects in it, and I can't cover all of that today. As this is a webinar, it's perhaps interesting to just point out that who wants to read more about what I'm just outlining now in the next 45 minutes. So this is the underlying paper. If somebody has appetite for reading in more detail about this, that would be the resource. As I said, it's the second milestone in harmonization of copyright law in the EU. So perhaps it's good to have an overview of the starting points of this whole development. The new legislation in the EU is basically something which the European Commission must initiate. The Commission has taken an initiative as early as 2013-14, which was a really large consultation on the so-called review of EU copyright law. This was a very open questionnaire, ranging from issues of strengthening protection to introducing more flexibility, fair use type rules, and so on. This was all in the package. Then in May 2015, the Commission came with, let's say, a paper that gave a broader dimension that set out the rules for a digital single market strategy, the digital single market being basically the free trade zone in the European Union and also covering Norway, Iceland, and Liechtenstein. And then in December 2015, I think this is the core communication, the central paper that embedded the digital single market strategy in the copyright framework. So this is where the Commission made the link to the copyright issues, and I will give you a couple of quotations from that particular communication. Then in 2016, we entered the final phase. There was a further consultation held on the second hot potato, which is not the central point today, but you might have heard that we also get a new neighboring right in Europe for press publishers. So this came out of this consultation. And then in May 2016, a second communication focusing particularly on the online platforms called Opportunities and Challenges. I think what we see now in the final legislation is predominantly challenges. I don't see too many opportunities, but that might be just a personal interpretation. And then in September 2016, the legislative proposal, and then the legislative process started. The whole thing went to the council, to the parliament, back and forth. We had the trilogue discussion between Commission, Parliament and Council in late 2018, early 2019, and now the new directive on digital single market copyright has been adopted. But before turning to the rules and discussing the rules in more detail, just a bit more groundwork. So I said one of the central papers where the Commission addressed this copyright framework from a digital single market perspective. This is the communication towards a modern, more European copyright law. And there the starting point was relatively neutral. The Commission pointed out, well, of course, there is interdependence of diverse creative content and innovative online services. So both, says the Commission, creative content and online services are important for growth and jobs and the success of the internet community, internet economy. Very utilitarian approach, you could say. Copyright is embedded in a framework that should make it possible for the players in the market to work together successfully. But, said the Commission already at that point, there is a risk of a value gap. And the value gap then developed into a very, very powerful argument. There is, however, says the Commission, growing concern about whether the current EU copyright rules make sure that the value generated by some of the new forms of online content is fairly shared. So this was already an indication that there is something which the Commission is really critical about. So what is this value gap? And I mean, in the further debate, it became obvious that it's basically one particular type of platforms. And this is, you could say, the YouTube type of platforms. It's not only YouTube, there are more platforms following that model, but the basic idea is that something has to be done about the platforms that are populated by user-generated content. So the platform only provides a general infrastructure, and then the users bring in all the content that is offered. And then the question was, well, how can it be that these platforms can offer all this content without entering into general licensing agreements? And there were comparisons drawn between this type of platforms and services like Spotify, Netflix, and so on that really look for umbrella licensing agreements. And then the answer was, okay, the safe harbor, which, I mean, from the beginning of the millennium, 2000, the e-commerce directive has been something that has never been called into doubt in Europe. I mean, it was very clear that the safe harbor for hosting, allowing those platforms to rely on a liability shield, basically, that this was suddenly seen very critical because the idea was that this allows the platforms to get the content for free. This has prompted, says the Commission, a growing debate on the scope of this exemption, this liability shield, and its application to the fast evolving growth and activities of new players, and on whether these go beyond simple hosting or mere conduit of content. So in a nutshell, the argument was, well, there are players getting rich, in particular US players, and they get rich just by not paying for precious content that very often comes from EU creative industries. The same point was made in the more specific communication on online platforms that followed in 2016. And then the debate was already at a stage where the safe harbor for hosting was clearly identified as a problematic element in the copyright arena. And then there were a couple of proposals. This is one of the most prominent examples, a paper that was added to the debate by the High Council for Literary and Artistic Property from France. It relies on a study conducted by Pierre Sirinelli, a famous professor from Paris. And there actually we see very clearly the strategy that followed. Nobody dared opening the e-commerce directive. In the European Union, the e-commerce directive offers a safe harbor across all different types of content. So not just copyright, but also all other types of content uploaded. So nobody wanted to touch this e-commerce directive. So a solution had to be found that is targeted specifically at copyright, enabling the effective enforcement, as this study said. And then very clearly the idea was, okay, we leave the general rules of the e-commerce directive untouched, and we take measures to neutralize the safe harbor for hosting when it comes to copyrighted content. So a carve out, you could say, that places copyrighted content outside the general safe harbor rule that would remain intact with regard to other types of content. And this model then, and this brings me to the new legislation. You may be sitting here wondering, okay, when do we finally learn something about what has been the law, has become the law now? So this is the model that we now see in the new legislation. So speaking about the new legislation, the new directive has now been published. So it's Directive 2019-790. And the implementation deadline is calculated on the basis of 20 days after publication and then 2 more years. So member states now have until 7 June 2021 to implement this. But you can imagine that for the national legislative process, I mean, copyright is, of course, a difficult thing in the policy debate also at the national level. So the implementation discussion has started already. So there are meetings held in Brussels between member states and EU representatives and so on, how to implement this in a harmonized fashion. So this is the official piece of legislation. When we look at the legal rules, the cornerstone that does the job of neutralizing the safe harbor for hosting is in Article 17(1) as adopted by the Parliament and the Council. And it says, member states shall provide that an online content sharing service provider performs an act of communication to the public or an act of making available to the public. So these would be the 2 central rights in the online environment in the European Union. When you post something online, then it's making available to the public for the purpose of this directive. When this online content sharing service provider gives the public access to copyright protected works or other subject matter uploaded by its users. You may wonder why I left a strike through here in the text. Well, this is the most important change that has been introduced during the legislative process, because at an earlier stage, the text read when it intervenes in full knowledge of the consequences of its actions. So the knowledge requirement, or at least the type of knowledge requirement as we know it from the e-commerce directive, but also a knowledge requirement that we saw in more recent case law of the Court of Justice. There was the GS Media case about hyperlinking to illegal sources, the Filmspieler case about media players that had a function that enabled also to display illegal live streams of sports events and things. And we had, of course, the Brian Sigo case concerning the Pirate Bay website. In all these cases, the Court of Justice made further steps to broaden the right of communication to the public, right of making available, but the court always did so on the basis of a knowledge requirement. The court always said we can broaden the scope of the right because those players know exactly what they are doing. If you are the Pirate Bay, if you're offering a file sharing infrastructure and you call yourself the Pirate Bay, then you know that people will use this for exchanging illegal uploads. And so the knowledge requirement always played a crucial role. So we can say that the legislator now takes the next step, and this is, I think, a very remarkable step. The knowledge criterion is now abandoned with regard to online content sharing service providers. Wonderful new EU terminology. So the more often you speak about the easier it becomes to say online content sharing service providers, but it's a very long word. When you look at the definition, you see that several players have managed to get exempted from the outset. So the legislation is very clear in saying we want to target certain types of platforms and others fall outside the scope. So online marketplaces, for instance, scientific repositories, on-site encyclopedia, and so on, they are outside the scope. So it's very clear that this is really about the content platforms. And again, the model that was used in the debate most often as an example of a typical online content sharing service provider was YouTube. You heard Facebook being mentioned also in the later stages of the legislative debate. So the knowledge requirement is gone. What does that mean? Well, basically it means strict liability. It means whatever is uploaded by a user to the platform makes you directly liable. So if a user uploads infringing content, then you are directly liable for infringement. So the platforms would have to find ways of dealing with this enormous liability risk that they are now exposed to a copyright claim. And this would not be secondary liability, this would primary direct liability. So the fact that you offer this type of platform makes you directly, primarily liable for any illegal uploads. But says the legislator, well, this looks a bit strict, but we don't want it to be that strict. And we offer two options for avoiding this liability. The first option is a bit like stating the obvious. Well, you can avoid the liability by entering into license agreement. So, okay, I mean, we would have known this anyway. Of course, if you get a license for something, then you are no longer in infringement as long as you operate within the framework of the licensing agreement. The second option is filtering. So if you don't manage to obtain the license, then you can still avoid this liability by making filtering work in a particular way. I'm quite critical about both options, so I think it's worth looking into that in more detail. The doubts I have concern in particular the practical implementation. I think there is lots of wishful thinking here, in particular in the licensing field. I mean, this is not licensing for a marketplace like the US, where you have one or two languages and you have a more or less integrated market environment. Now, this is licensing in an EU context, and there is another rule in the new directive saying that this licensing task is a very challenging one. Member states shall provide that when an authorization has been obtained, including via a licensing agreement by an online content sharing service provider, this authorization shall also cover acts carried out by users of the service, falling within Article 3 of Directive, and so on and so forth. So the idea is that the authorization shall cover whatever users upload. And this gives the licensing negotiations a very strange flavor, because we are speaking about user-generated content platforms. So let's say you manage to sit around the table with representatives of rights holders. So you have found the right people. And then they say, okay, you want a license. Tell us for which types of works and so on you need the license. And then you say, well, I can tell what is on my platform now, but if these negotiations take 2 or 3 hours, then this might already have changed, because I don't know what my users are uploading as we speak. We are basically asking for a license for a moving target. You don't know what users will upload in the next days and weeks and so on until the licensing agreement is finally concluded. And so this creates, I think, a challenge for both sides. In the debate, people have very often said it's a challenge in particular for the platforms who have to make best efforts to obtain these licenses. And there is an enormous rights clearance task in light of the content diversity of online platforms and the changing content. But I think it's also a challenge for the content industry, because the legislation openly asks, okay, is the content industry willing to grant these umbrella licenses? What we see in the debate right now is that the answer is not so clear. The music industry seems to have not too much difficulty with this, because they are already used to, let's say, these umbrella licensing deals. When you offer licenses for whatever radio stations broadcast, then it's not such a big step to say, okay, we grant you a license for a broad repertoire of music. The film industry is really a different story, because the film industry has this exploitation cascade. They start with a cinema exploitation, then pay TV, then regular TV, then video on demand services, Netflix, and so on. So I guess they would like to keep these exploitation steps as they are, and then they would rather offer a license saying, okay, if we have completed all the other things, you might have a license for use on a UGC platform. The problem here is this is not what users want. I mean, UGC platforms have become really a forum for debates, and then people want to debate what is in the cinema at this point in time. People don't want to wait and then post mashups and parodies and remixes of movies that have been in the cinemas 5 years ago or something. And it's also a big challenge for the film industry to imagine that in parallel with the official release in the cinemas, you would have a universe of mashups and things coming up on user-generated content platforms without really having the strong enforcement option of saying we prohibit this altogether. So this will be a critical thing to see how the different industry branches behave and position themselves in this debate. There are, of course, other also powerful players in the European Union. If you can't get the license from the content industry directly, perhaps you can get a license from collecting societies. The more north you go, I mean, in Scandinavia, you have quite well developed systems for extended collective licensing and so on. So the collecting societies might be able to offer some solutions here, but they again struggle with the umbrella license approach, because they have content of members and not of non-members. So with extended collective licensing, you get the non-members on board as well. But how about indemnification against claims of non-members that are brought directly against the online platform? In that respect, the collecting societies have not been so flexible, which is not surprising, because they are author and other right owner-driven organizations, and they think very carefully about the scope they can give to the licenses. And there is, of course, an elephant in the room, and this is what I indicated earlier. You would need cross-border licenses for the entire EU territory. So good luck with this one. So when you think about film, in the Netherlands, for instance, we have a collecting society for the directors, we have a collecting society for the scenario writers, for the composer of the film music, for the actors, and so on and so forth. And well, so you can imagine that there are similar collecting management infrastructures in the other EU member states. So
you now have a digital single market, wasn't it the whole point?
Well, actually, no, that's a very good question, because one of the issues on the table was, why don't you establish an EU-wide collecting society for that purpose? But this is something, I mean, the collecting societies like the infrastructure and the complexity which the system has at this point in time. So this issue really has not been resolved. So it's not clear where these umbrella licenses would come from. In particular, it's not clear for all different types of creative content. And so I guess the risk is really that we lose quite a lot of user autonomy and freedom of expression. We know that the whole debate about user-generated content is, of course, the revolutionization of the content creation and sharing process. Users become active, users contribute themselves to what we see on the internet. There is no filtering any longer by saying, okay, I have to find a professional publisher or producer first, and then I have to make sure that this ends up in the cinemas or on the bookshelves or something. The users have been emancipated, but I think we may lose quite a lot of this open, participative internet if the final result of this legislative step is content platforms that resemble TV channels in the sense that they can only offer content and only permit content mashups that fall within the licensing package that they have. But that's a risk if this whole licensing framework does not work well. So what the OECD described very well, I think, in a 2007 study as the advantages and the big opportunities of the Web 2.0, as it was called at the time, is something that we may lose. What I also find very interesting, looking back at the whole debate, it's now clear that both sides, both industry circles have found their figure. I mean, in intellectual property, we have this, when you want more trademark protection because you are a producer of luxury goods, then you say, oh, we have to protect consumers against confusion. So the figurehead is the consumer because this is a vulnerable party and so on. In the copyright arena, the creative industries, from the very beginning of copyright, has always said, well, we have to do all this for the author, that the individual creator gets more money, can earn a living, and so on and so forth. And now the, let's say the online platforms have found their figurehead in the form of the users. I mean, they want to help users and enhance freedom of expression and so on. So this is just a comment on how the debate took shape. So this is what I wanted to say about licensing. So I'm not so sure if, well, to say the least, I'm rather critical about the licensing option because I think there are many hurdles to take. And I don't see these umbrella licensing becoming available very easily in the European. Which brings us to the second point. If you do best efforts to obtain a license, but the license is simply not available, then you can avoid liability as a platform when you do filtering. And now many people would say, well, what is this filtering rhetoric? The word filtering is not in the legislation and so on. That's true, but this is a bit like referring to weapons, not daring to say weapons, and then you call it defense technology or something. So platform providers are liable for infringing content uploaded by users unless they made, in accordance with high industry standards of professional diligence, best efforts to ensure the unavailability of specific works. Well, and now, I mean, tell me how you ensure the unavailability of works without automating the process. Of course, you could hire hundreds of copyright students, and I mean, perhaps at universities, we could react to that by offering copyright just in the first year. So the bachelor starts with a copyright course so that for the rest of your student time, you can earn a living by ensuring the unavailability of works. But that's not realistic. I think the reliance will really be on technological measures. And then the next issue coming up, and you may have seen in the news that this is an issue brought up already by one of the member states, Poland, has brought a challenge against the new legislation on the grounds that it is incompatible with fundamental rights guarantees, and they focus on the censorship element, as they call it. There is some truth to it because the Court of Justice has been very clear in the Skynet-Sabam decision. There's a parallel decision on a social media platform, which would be the Scarlet Netlock decision. No, the Sabam Netlock decision, where the Court of Justice said, considering the fundamental rights guarantees involved, freedom of expression, privacy, freedom of conducting a business, we must state very clearly as a court that general filtering obligations are impermissible. You can't impose a general filtering obligation on a platform provider. Well, the argument now is that the new legislation does not establish a general filtering obligation because the new legislation puts the focus on specific works that are notified by the creative industry. So you only have to filter after the creative industry told you that they have rights to particular works. And this makes the whole filtering exercise specific. Well, I mean, I see many people with question marks in their eyes because, of course, what the creative industry is likely to do, I guess, is sending long, long lists of all the things they have in their repertoire. At least this is what I would do. And then adding up all the information coming in, all the information in those long lists from the different creative industry branches. You could say that, well, these bits and pieces, finally, we get to a filtering obligation that resembles a general filtering obligation as rejected by the court in these cases. We get very close to this general filtering scenario. So that's something that is unclear, that is to be resolved by the courts, and perhaps the initiative taken by Poland will already give first indications. I'm not so sure. Another point that is striking is the focus on industry cooperation. As I see it, the internet is the most important information medium which we nowadays have. If something is not available on the internet, then it's not to be found. So this is the main resource, which also makes it the main tool of sharing content in Western democratic societies. And then my question is, how can you leave this issue of filtering to the industry? And this is not against the industry, but this is, I mean, when we leave this to industry players, then what do you expect them to do? I mean, industry means their decisions are efficiency and cost driven. They have to maximize their profits. This is not unethical. This is not bad. This is just how the industry behaves and how it is supposed to behave. So if you leave the issue of filtering, or to use an even uglier word, censorship to the industry, then you can imagine these roundtables where content industry representatives get together with the platform industry and they say, okay, how can we achieve the desired filtering at the lowest cost, most efficiently? This is what will happen. And I miss the democratic control. There's only a very soft obligation in the new legislation that says, well, the Commission will organize from time to time stakeholder dialogues, bring the people around the table, exchange information on best practices and so on. I'm not saying this is nothing. Of course, this is something that can help, but it's not efficient. I think the legislation should have said these filtering schemes that are arising under the new legislation must be brought to court and must be checked and double-checked with regard to overarching public interest. So this is missing. And there's another point. Of course, this involves market concentration. The whole debate in Europe, I think it's fair to say, was very much against the US majors. So very much against the most important internet players. And when you look at the final result, and the result is quite a far-reaching filtering obligations, then we can say the big players already have quite sophisticated filtering systems. So when we read high industry standards of diligence in that area, then I think the highest standards, actually the standards reached by the content ID system as Google has developed it, for example. And there are other players, of course, who have developed these content ID systems. So they will set the industry standard, which puts other players, particular small newcomers, into a very difficult position. If you want to start your new online platform in the European Union, you do not only have to think about the investment coming in, you also have to think about, okay, where do we get these filtering mechanisms from? And then the question is, if you don't have much financial resources, then you are likely to do more than is necessary. So I think excessive filtering will be the rule rather than the exception. Because if something slips through, then you are directly liable. If you block too much content, then okay, users might be a bit unhappy and so on, but there is no hard result as in the case of missing something. So I guess the tendency of over filtering, excessive filtering is really a very difficult problem arising from this. Well, the legislation reacts to all this risk of further market concentration, extra entrance barriers for small players, by including a small and micro business privilege, which is based on hard facts. So a turnover of less than 10 million. You are now, I think another rule is that you have not operated for more than 3 years and so on. So it's quite a clearly defined framework, but within that framework, you do not have to filter at an early stage of your company. So this is.
Martin, can I just ask about that? This small micro business privilege, when you hit the ceiling on that, then suddenly you're up there with Google trying to figure out.
Yeah.
Okay.
Yeah. Well, I mean, you can of course invest yourself. There are all different types of models that I discussed. Perhaps we see joint efforts of smaller companies to develop filtering systems in some pool. So I don't know what will happen, but it's quite clear that all the players in the European Union now have to think about obtaining these filtering systems. And it's correct. I mean, the moment you go beyond this 10 million threshold, you have to implement the full range of measures. Yeah. You're fully exposed to the new obligations. Yeah. So, I think I was clear in also making a couple of critical comments on this filtering scenario. So, yeah, I think there is lots of wishful thinking in the legislation. So the legislature just hopes that the industry will find some way of dealing with these rules. I'm not so optimistic, so this is why I have also looked into further options that might be a bit underdeveloped, but could be cultivated in the implementation phase. And something that I found really a positive element of the new legislation is a provision which you could also say is wishful thinking, but wishful thinking concerning a very important point, the cooperation between online content service providers and right holders shall not result, it's a shall provision, shall not result in the prevention of the availability of works or other subject matter uploaded by users which do not infringe copyright and related rights, including where such works or subject matter are covered by an exception or limitation. It's a shall provision, but nobody knows how to do this. I mean, the filtering mechanisms, at least to my knowledge, are not clever enough, not sophisticated enough to distinguish between an infringing copy and a permissible parody. So we don't have these filtering mechanisms at this point in time. I don't know if self-learning artificial intelligence systems will sooner or later make it possible to draw these distinctions, but for the time being, we don't have this technology. So what is the answer of the legislator to this shall provision in the light of non-existing technological solutions? Well, the focus is on complaint and redress mechanisms. So the legislation is very clear that the exceptions that are particularly relevant are quotation, parody, pastiche, these kind of uses. And then if users feel that something has not gone through the filter, which is permissible, they can send a complaint. And then the platform has to deal with this within a reasonable period of time. There are a couple of checks and balances. So the rights owners in such a case have to give further explanations why they think it is infringing and so on. I'm not so sure that this system will be very successful because users normally want their content to go viral immediately. So if as a user you get frustrated because it didn't go through the filter the first time, then it's nice to have a letter or an email finally after 2 or 3 weeks saying, oh, we are so sorry, it's now available on our platform, but the very moment for catching attention it's on might have gone.
A serious question, is public domain material included in what's covered by an exception or limitation? Because that can be very, very easily captured and prevented. But I don't. Does the national law or European law consider public domain within an exception or a limitation?
Well, I think public domain would be covered by what I said earlier. So it's works which do not infringe copyright and related rights. So once the work has entered the public domain, it is no longer
That's an including.
infringing. So I would say it falls under this. But the point is well taken because, I mean, on top of that, we would need filtering mechanisms that are intelligent enough to calculate the term of protection. So if something has been entered into the content ID systems that are used for filtering purposes, then the moment the work enters the public domain, it should automatically become freely available. And I'm not so sure if this is very realistic. But again, perhaps this is something to be developed in the future. Still, I like this provision because I see a particular implementation option here. What you can do as a national legislator is you can broaden the scope of these exceptions and limitations. So why not using a broader limitation in that context, which brings me to, let's say, a third alternative, not only licensing filtering, but also privileging user-generated content. So why can't we have a legislative framework that introduces at EU level a UGC privilege, something which we have seen in Canada already, and then on that basis, trying to change the dynamic here a bit. So let me explain this idea in a bit more detail. It's not an easy step to take because European copyright law is not a very exception-friendly environment. So as you will all know, we don't have a general fair use clause or something in EU copyright law. Instead, we have broad exclusive rights. And then user privileges are only possible if you find some relevant type of exception in the closed list of permissible copyright limitations in EU legislation. What gives me hope in that context is Article 5.3k of the Information Society Directive 2001. This is the provision saying that copyright can be limited in order to exempt types of use that fall in the category caricature, parody, or pastiche. And now the question is there anybody here around the table who knows what pastiche actually is? I have asked this question several times already, and European audiences have very diverging views on what pastiche actually is. And I think it is a very open term. The Italians told me that the origin might be Italian, pasticcio. I'm not sure if that is true, but I mean the important thing is that pastiche can mean many different things to many different people. So it can be a style imitation. This is something I hear more often, but it can also be a medley, a hodgepodge of just different bits and pieces and so on. So I think this is a pastiche. I think that many types of user-generated content are pastiche in the sense that they combine something which the user has created. So here, this is the example of the funny animal videos. You have also funny baby videos and whatever. And of course, you need a bit of music in the background. I mean, most of those videos come with background music, and the background music, strictly speaking, is infringing because it's not a quotation, it's not a parody, there's nothing done to the music. So if the context with the video does not create a parody context, then this would be infringement unless it is a pastiche. And I would say we can argue that these types of uses are pastiche, where users combine their own creative contribution with something that enjoys copyright protection. And then you could apply this example to many other forms of user-generated content, the lip-syncing examples, and so on. So if you accept this, then there is hope that the Court of Justice could also accept this and actually give the word pastiche a meaning that goes nicely with the general notion of user-generated content. We have the decision in the Deckman case, which is the leading parody case at EU level, where the court basically harmonized humor in the European Union because the court said, well, parity, this is an autonomous concept of EU law, so we can harmonize this aspect of humor. And if the court can take this brave step in the area of parity, I think the court could do the same with pastiche by just saying this is an autonomous concept of EU law. So it's a legal terminology, term of art, and we can give it a particular meaning. And then based on meaning in everyday language, the court could say that pastiche is broad enough as a concept to cover user-generated remixes, mashups, and so on. So I see there some opening in the legislative framework. And then there's a final step we have to take, and this is the famous three-step test. I don't know how many discussions I followed in the PGIP context already on the three-step test. So I think you are well aware that in the European Union, we have a very specific type of three-step test, and this is Article 5.5 of the InfoSoc Directive, which says that all the exceptions and limitations that are permissible also have to comply with the three-step test. So the wording that you see here is taken from international law, but the function is very different. At EU level, the three-step test has lost its enabling function. The three-step test is a tool for further restricting uses that would be permissible. But I think in that case, there's a good argument to be made that we can use the three-step test productively, because the starting point of the whole legislation is to say we want to close the value gap. So if we permit these types of uses, then there should also be a revenue stream. So how do we generate the revenue stream? Well, we can generate the revenue stream on the basis of the three-step test. We can say that this broad user-generated content privilege, this pastiche privilege, requires remuneration to be paid. And I have another paper. So if you want even more reading, then this could be a good read on the three-step test questions. And I built on earlier work. I mean, Peter has written about this in the Hong Kong debate and so on. In a nutshell, the proposal is to follow something which in the European Union is already long-standing legislation in the field of private copying. So we have the private copying levies that would be paid by importers and producers of blank media and copying devices. So if you buy a smartphone in the Netherlands, for instance, you pay €5 extra, and these €5 go to a collecting society for private copying. They generate about 40 to 45 million euros every year in the Netherlands. So it's substantial, it's really money. And I think we could do the same by saying users enjoy this freedom of remix and mashup on the basis of the pastiche concept, but the UGC platforms pay levies. So they pay a lump sum, I don't know, a certain percentage of the advertising revenue or whatever. And then the collecting societies pass on the money that they collect to individual creators. So that's something which I like about this solution. You see, the legislative framework is very much based on industry cooperation. But if the industry agrees to do something, then the money is still not in the pockets of the individual creators. So if the platform industry and the creative content industry agree on licensing and filtering, then the content industry may become richer, but the content industry need not pass on that money directly to individual creators, whereas a collecting society would do this, at least if the collecting society is based on involvement of the individual creators as the persons who give the authority to administer these rights. I also see here a chance of establishing an EU-wide, a new collecting society that would operate EU-wide. So this would be a pastiche remuneration collecting society established centrally somewhere in Europe, collecting the money for the entire digital single market, and then pass on that money to the individual collecting societies representing individual creators in the member states. So basically the further repartitioning and distribution would have to be taken care of within the collecting society framework. But as a starting point for the licensing, you would have as a one-stop shop an EU collecting society for the pastiche remuneration. So that's also an element that I find important and that I find can add a bit of a positive nuance to the whole legislative model. I also see a further advantage, and this is the advantage of changing the whole approach a bit. The legislation is based on a focus on takings from protected works. So very much the content ID idea, the creative industry provides the necessary information for identifying protected works. And then if something you want to upload contains certain snippets, fragments of a protected work, then it would not make it through the filter. With this pastiche idea, the focus is more on the creative elements added by the user. So I imagine filtering systems that go further, that do not only ask, okay, is there something protected in it, but also, is this protected element important enough to devalue the creative elements added by the user? So basically, you would need a filtering scheme that says, okay, this is content that contains 5% taken from this source A, 10% taken from this source B, another 10% taken from source C, but there are also 75% that I cannot match to any protected content. So these 75% must come from the users. This must be the user creativity added to the content. And then that could change the equation. Perhaps we could even establish rules by saying, well, if there is not more than a certain percentage of content match, then this is presumably a permissible pastiche for which remuneration has already been paid, and this can pass without further filtering. I only have started discussing this with technology people. They tell me that this is definitely not how filtering systems are designed for the time being. But on the other hand, there seems to be room for that. So this is why I'm so very happy to be here at Microsoft at the moment. So this is something that I guess could be explored in a bit more detail. How to give the whole filtering logic a broader approach by saying we should not focus only on the protected elements, we should also take care of creative elements added by users. I guess there is another way of doing this, but this would be more complicated if we establish a parallel world of user upload. So users upload what they have created themselves. So the funny animal video, they upload this in isolation to a database of user-generated content. Then we have a parallel world of, let's say, the database for copyright-protected content, which the industry wants to enforce. And we have a parallel database of user-generated content, which users want to share freely. And then I guess it's easier to match the things and to get information on the individual components of something that is uploaded. But yeah, I'm not a tech person myself, so I can just, as a humble lawyer, I can just imagine some of the things that might perhaps give a particular direction to the debate on filtering. I must admit that there is one final point. This proposal, and I have to be very clear in saying this, this proposal is not intended to establish remuneration rules for types of use that have never been under a remuneration obligation in the past. So in the European Union, there was no discussion whatsoever in the past that quotation in the traditional sense of the word and parody in the traditional sense of the word is free. So there was nobody ever standing up saying parody is a permitted but remuneration-based use privilege. So this has always been free, and of course, this must remain free. So my proposal would only be to link the pastiche in a broad sense, the broad pastiche concept that covers types of UGC, where protected content has really been linked and mingled with user-generated content. Only those cases would fall under the remuneration obligation. How can you draw the line in practice? Well, I think a bit about the models of radio stations where you also make assessments of which percentage of the broadcast is content which the radio station does itself. So are they offering lots of news programs, discussion programs, and which percentage is music? And then only for the music percentage you pay remuneration. Perhaps something like this could be established here as well. But I must admit that this is from a legal doctrinal perspective, of course, a bit of a challenging point, but I don't want this proposal to pave the way for the next step in legislation saying, okay, wonderful, we get remuneration for all these types of uses, so quotation and parody would fall under remuneration as well. And then universities suddenly have to pay remuneration for all the quotations which their students do in their master thesis and so on. So that's definitely not the intention here. So yeah, that's it. So that's a bit of an overview what you find in the legislation and a bit of my own comment on that. I hope this can be a good basis for our discussion. Thank you so much.
Thank you.
So I will take over the moderating of this next step. And thank you all for coming. This is an incredibly special group. So all of you are invited here because you have, special elements of your experience that are directly related to what we're discussing here today. And I think, and we're especially pleased to have a couple professors who have joined us from other places because they're here from the Law and Society Conference. So we expressly kind of planned this meeting at a time when others could join us. So we want to take advantage of their experience. But there's a couple levels that this conversation can go, and I want to just at the outset encourage you all to ask each other questions, in addition to the presenter. But we have a great mix of people from the technology sector, of lawyers and professors who work in this field, and people who have expertise of what's going on in different countries. And so I want to kind of encourage people to bring out that different experiences, both in the form of and in comments as well as questions. So you don't have to direct all of your comments or questions to the speaker themselves, but I think it would be a good time to kind of share with each other and through the general audience of what's going on in this space. So I wanted to start off with a couple of our guests. So you mentioned Canada and Hong Kong specifically, and since those two professors are sitting closest to me, I wonder if we can start off with those places. But so maybe Karis, to start off with you, and please reflect on anything, but Martin mentioned that some of this idea actually comes from Canada of having kind of an express UGC privilege built into the law. So how does your knowledge of how that's working in Canada and any kind of reflections upon that you have suggest on whether that model is working? And also, what are you kind of hearing in Canada? So, part of Michael's framing was that for a while we were all on the same page. Europe's now going a different direction. Is that different direction? Do we have already a sense of that different direction becoming viral, or what do we hear in different places since Canada itself is going through a copyright?
Right.
Any of those?
Thanks, Sean, and thanks, Martin, for that wonderful sort of introduction to our overview of what's going on in Europe and some possible ways forward. It was a really interesting paper to read and a really, I think, troubling thing to learn more about, because I think around the world and in Canada also we've been watching with some degree of fascination over the way that things have been developing in Europe, and also some wariness about what it might portend for the future of copyright development in Canada. So I thought I might just quickly say that, yes, first of all, we are in the midst of this parliamentary review of the Canadian Copyright Act, and particularly the 2012 amendments that were enacted in part to bring us quote unquote up to date with technological developments. So these were the changes in 2012 that, for example, added anti-circumvention measures. They created not a notice and takedown system like the DMCA system, but rather a kind of made in Canada approach to notice and notice. So the internet service providers have an obligation to notify users when they've been informed that an infringing content has been posted or infringing activities have occurred. So already we had a kind of made in Canada response to some of the sort of pressures that were put on Canadian lawmakers to ensure the protection of content in the online environment. It was also the 2012 Act that introduced our non-commercial user-generated content exception, which was designed, I think, to deal specifically with the kinds of examples that you gave us about sort of non-commercial new works created by users that might contain existing copyright-protected works, and basically to carve those out of the copyright sort of liability system so that users could post these and they could do so without worrying about liability, and also that service providers could host them without worrying about liability. So what's happened is that there was a 5-year review, which basically, depending on who you ask, was an invitation for lobbyists to kind of mobilize with the hope, I think, of both expanding some of those protections that didn't go so far as we saw in the US in particular, and also trying to roll back some of the new exceptions. The focus has been less actually on the UGC exception than actually the expanded fair dealing provisions. We took the opportunity in 2012 to add parody, satire, and education as permitted purposes for fair dealing that would take you to a fairness assessment and allow ostensibly fair use for those purposes. And that's where I think the major pressure point has been. So I thought if there's a couple of points that are worth making about the difference between where Canada is right now and where the sort of current status of European law that sort of propelled you into this directive. And I think the most important thing is just the limits on the kinds of activities that currently implicate copyright holders' rights. So we have a sort of clear limitation on authorization liability, so that merely providing the means by which infringements might occur is not authorizing infringement. Merely providing the means by which communications occur is not communicating material. Merely providing links is neither communicating nor reproducing. And so a lot of work is done in actually circumscribing those initial rights, and that comes from a body of Supreme Court jurisprudence that limited essentially the communication to the public right in very important ways. And then, as well as I've said, the responsibilities of service providers are kind of limited by the notice and notice regime. And then we have this body of user rights, which have been described as such by the Supreme Court. So fair dealing, UGC, these are not just limits and exceptions, but they're understood to be user rights in the balance. So I think that puts Canada in a nice position to kind of withstand some of these pressures. On the other hand, this is precisely why we have a heightened sort of political discourse around these things in the context of this copyright review. So certainly that we have two committees, the industry committee, which is producing the main parliamentary review, and then we have a heritage committee, which was asked to provide a review or a report on remuneration models for artists in the new digital or technological context. The latter report has already come back, which is the heritage report. And I know a few people, I've already spoken to a few people here who saw that report when it was released a couple of weeks ago. And I think that it's fair for me just to say it's an appallingly one-sided document. So it simply took the recommendations, the proposals, the most far-reaching dreams of the content industry lobbyists that were presented to the committee and basically rubber stamped them as recommendations to the Canadian Parliament. So these included, for example, and I think this is the most important thing for our purposes today, multiple uncritical mentions of the value gap that creators are suffering. So that value gap rhetoric was not even actively endorsed, it was just embraced and employed uncritically, right? And then a sort of emphasis on the decline and the suffering of the artistic middle class, which no longer exists. So a lot of talk about artists and authors not making any money anymore, the negative impact of technology on creative industries, and then noting as well that ISPs, meanwhile, quote unquote, enjoy and greatly benefit from access to the music they give their clients. So already setting up, I think, precisely the same policy frame as we've heard described about Europe, and using that, I think, as a foothold or a foundation for getting there. So amongst their recommendations were that the government reviews safe harbor exceptions to ensure that ISPs are accountable for their role in the distribution of content. Again, I'm quoting. A recommendation that Canada increase its efforts to combat piracy and enforce copyright, and a recommendation that we review, clarify, or remove exceptions in the Act that to ensure that they all respect Section 9 of Berne, otherwise known as the three-step test. So that was that report, and it's clearly positioned where the Ministry of Heritage, or at least that committee, landed. Now, hopefully we see this for what it is. We're waiting for the industry report. They spoke to, I think, a more diverse range of stakeholders, and hopefully we're going to get something more balanced coming out of that. But I think we're really at a pivot moment in Canada where we can learn and take heed from what the Supreme Court has told us about balance and user rights and limiting intermediary liability, or this political rhetoric is really going to gather steam and it's going to sway the people who are holding the pens when they're rewriting law. So I don't know if that's a bleak outlook, but certainly I have some concerns.
So, I mean, you mentioned the Supreme Court's embrace of the user rights concept, and describing it as a right, which kind of echoes, some of U.S. Supreme Court statements about the relationship between the First Amendment and copyright, for instance. What do you have a view on? So, if a similar proposal as the EU that pushes, if not requires, kind of filtering mandates that could go quite far, of how the court might treat those in Canada? Do you have a sense of that, or?
I mean, the difficulty, of course, is that the court itself is always changing in its constitution and its makeup, and we have actually, I think, 3 sort of litigation files that are making their way through the Canadian courts that might, either sort of reinforce the language of user rights and hold steady on that front, or that could do some damage to that and represent a sort of reversal, which is what we've seen in the lower court so far, right? So people are perhaps aware in particular of the York University case with Access Copyright, which is the copyright collective that does sort of educational reproduction rights. They're suing my home university for not paying the license fees, and the lower court ruling in that case was very much a step back from. I mean, it used user rights language, but it had a very limited, restrictive understanding of what constituted fair dealing in educational context. That's currently we're waiting for the Federal Court of Appeal ruling on that. We have another one on parody where someone posted a parody of the United Airlines logo, and the lower court found that that was infringement, that the fair dealing for parody didn't apply because it wasn't humorous, and pointed to the European harmonized understanding of humor and found it not funny enough to constitute fair dealing. So that we're waiting, actually the litigation for that is likely to take place in the fall. And meanwhile, we also have this effort to do a mass sort of reverse class action against end users. In the Voltage case, where Voltage Pictures are looking to sue over 50,000 Canadian end users for torrenting particular movies using a reverse class action mechanism, and that's in process now. So it's also moving towards targeting the end users en masse rather than focusing on the intermediaries. So I think in each of these cases, what we're going to test is whether the Federal Court of Appeal is on board with what the Supreme Court had to say about user rights and copyright balance. And then I suspect in at least 2 of those, we're going to end up back at the Supreme Court. But we no longer have Chief Justice Beverly McLachlan at the helm. She was the one who wrote our CCH case about user rights back in 2004. And so some shifts on the bench could, I think, spell the future of fair dealing and user rights in Canada. And also, we hope, of course, it doesn't have to come to that, because at the end of the day, the statutory amendments are the ones that are going to hold.
Peter, let me bring you in. I mean, so in addition to being a U.S. law professor, you spent a lot of time working in Hong Kong and China and have good relations there. And, Hong Kong seems to be at a particularly interesting point. I mean, the last round of copyright reforms literally led to fisticuffs in the parliament, as I recall. And my understanding of where things are is that the proposals, which at one point included a fairly strong fair use provision, but that those proposals have been stymied and that there's a new kind of effort to figure out what's going to come next, and how does what happened in Europe, how do you think it's going to play there? And to the extent I know even less about China, other than there's been a copyright reform sitting there for many years, it seems, and I hear very little about it. But your reflections on either of those pieces?
So, great question. Nothing is happening at the moment in Hong Kong, in part because of how difficult it was when we were trying to get through the 2014 bill. And so, as you mentioned earlier on, there were two highly controversial proposals. One is about fair use. So what the legislators were trying to do is to add an additional catch-all provision so that it's not just the fair dealing based on different exceptions, but you also have something that is closer to fair use in the US. And so that's one proposal. The other proposal, which actually makes it very good to follow Kerry's, is a number of legislators were trying to introduce Section 2921 from Canada as a way to promote user-generated content. And so there's a special exception for UGC. And that's also highly controversial as well. What's quite ironic in the debate is that they were so tied up with the discussion of other issues, they were not able to get to those two proposals on the floor, even though those are the most controversial. But that gives some idea as to how difficult the debate was. So Hong Kong is probably too small a jurisdiction for this group, but I think it will be important for two reasons. One is that it used to be a gateway to China, and it still has a lot of very close engagement with both policymakers and businesses in China. And so a lot of the industries as well as foreign governments are hoping that Hong Kong will be a place that will help change the development of the IP system in China. So I think that is quite important. The other thing which I observe closely is that what plays out in Hong Kong, especially behind the scene, is actually quite similar with Australia, Singapore, South Africa, and a number of former British colonies. And so what happened in Hong Kong may also provide some insights into the development in other places. And that's why I think your question is actually get to a very interesting story. When we were trying to, so I was the proponent advisor to some of the legislators in Hong Kong. When we're trying to get through some of the proposals, we are in a very interesting set of circumstances. One is that the bill did not get to a legislature, to the floor of the legislature until after the umbrella movement. And so that was the major protest in different parts of Hong Kong. And that changes the landscape completely because we move from the discussion about how we need to offer better protection to corporate holders to how we can better protect freedom of speech in light of what's going on in the past 3 months or 6 months or so. And so that is quite different. I think it's also quite different in the sense that Hong Kong doesn't have a lot of corporate litigation. So what is at stake there is actually not so much about changing the corporate system in Hong Kong, but more about not setting a bad precedent in Asia so that it will affect other countries, or not having this one to affect China. And so the discourse is quite interesting in the sense that we are a little bit detached from what's going on in Hong Kong, because everybody knows that no matter what happens in Hong Kong, there's not going to have a lot of cases going to the court about copyright disputes. It's more about how we don't want to have another jurisdiction having the UGC or having fair use so that others are following suit, right? So that is basically the dynamic. So what we ended up with is there are 3 different issues that are very important to the corporate industries, but that were not on the bill, not in the consultation, and that they were very eager to get to, but because of the bill started from a consultation way back in 2006, which is a totally different world. And we were not able to get to that. Those 3 issues are set-top boxes, basically the last mile discussion here in the US, link aggregation, Pirate Bay, and as well as a lot of the discussion that's going on in the EU as well. And the last one is basically website blocking. And so how do we block the different website? And I think UK, especially in light of what Justice Arnold has been doing, will be a very good example of what a lot of the policymakers in Hong Kong are very interested in. Right. So those three issues do not get to the table, and I think that will come back if we are going to have another round of consultation or another bill. And I think this directive will actually be quite influential in that next round of discussion. And I think there are a number of reasons why it will be quite influential. One is that I think that's true for policymakers in Hong Kong, but true for other policymakers in our jurisdictions as well. They love to transplant laws from major nations, whether it's US, whether from EU. And so having this directive is very effective. And that's one of the reasons why I was very eager to use the Corporate Modernization Act from Canada so that we have a transplant fighting a non-transplant, right? One of the challenges to propose something is that if you do not have it in a law of other countries, the standard question I got from policymakers is, have we seen this in other places? If you say no, then you're not going to be able to move too much forward. And so having that will be quite useful. And I think the directive will play a very important role there. The second thing is that in Hong Kong, because of the fact that Hong Kong was a British colony, there are still a lot of people who are in the British mindset. And so this is actually very surprising to me. Also, how should I put it? This is very interesting to me, but not so surprising because I actually grew up there and I see it coming. So in that debate, the legislators keep on talking about how Hong Kong is British and it's a British system. And we all know that Hong Kong has now become part of China. And so that was quite interesting. But at the same time, we also understand why they're coming from that direction, because most of them are trained from there. They do a lot of education there. They have working closely with a lot of British companies, and those in the industries also work very closely with the British industries. And so that's why that's where they're coming from. And I think the EU directive will also be influential in that way because it's more from British or from the Europe as opposed to from US and other places. Now, how that will play out with Brexit, I don't know. But at the same time, I think there are enough people who actually spend time talking about how we need to protect, we need to create an exception for pastiche, and not knowing exactly what it means, right? So that shows a very good example of how they are very into what's going on in EU. I think it will be quite interesting if we're going to jumpstart that round of consultation or having a new bill in terms of what are we going to put on the table. So obviously some of the issues with respect to this directive will be on the table. Those three issues I mentioned about set-top boxes, link aggregation, and website blocking will be on the table. But the way consultation is being done in Hong Kong is, if you're going to put this on the corporate side, you also need to put something on the user side, right? So would that be fair use? Would that be UGC? If those are the only two things that are being put in the consultation, those are already in the last bill. So you need to add additional things in light of the other things we are adding to the consultation. And I don't know exactly where they're going with respect to that. So let me wrap up by saying a little bit about China as well. So right now, the process with respect to amending the copyright law in China has slowed down quite a bit, in part because the person who was in charge in the reform has retired. And so they basically have to figure out how to move forward. But while they're trying to do that, we have the US-China trade war that's ongoing. That might affect a lot of the discussion. I think what's quite interesting is that China has revised a lot of those laws that are problematic, at least from the WTO standpoint. For example, about technology import and export. And if that is the case, China is not going to use copyright as another bargaining chip to try to get into that debate. And so that means copyright reform will be in the back burner for the moment. But with respect to this directive, I think what will be quite interesting is that there are two different issues I think Martin mentioned. One is about licensing, the other is about filtering. And with respect to licensing, I think is something that the policymakers are very eager to to utilize, in part because part of the reform in the last few years for the corporate amendment is about how to improve the corporate management system in China, about collecting society, about a lot of those provisions that are relating to licensing, collective management. And so the discussion about licensing will actually play into that debate. But I'm unsure whether a lot of the rights holders will actually be happy with the current arrangement for collecting societies in China. If they're not happy, then we are probably talking about apples and oranges, because it will only work if we have a licensing system that is closer to what a lot of the industries are hoping for. If we don't, then the discussion will be totally different. The same thing about filtering. China actually has more sophisticated filtering than a lot of the discussion we are now having in the corporate realm, right? Because it's about political issues, about other sensitive materials. And so the issue about filtering is actually somewhat different from what we have. I think one is that a lot of the, for example, the list that Martin mentioned, those are probably the content that has not surfaced in China for at least a large part of the list. And so it will be quite challenging for a lot of the companies to actually figure out what those contents are. It's one thing to say that, well, everybody is now watching Game of Thrones in the US, so we know exactly what it is. If it's not being shown in China, or it is not yet even marketed, that becomes quite complicated. So that's one issue. I think the second issue, which is also quite typical with respect to a lot of the online operators, is that how responsive they are to the corporate holders. I think I just read the report from USTR on Alibaba. One of the biggest complaints is that while they're not very responsive to a lot of small and medium-sized enterprises with respect to trademark infringement, and I suspect that will be true for a lot of website operators in China as well. They will not be that responsive to a lot of the corporate holders, and that would be a major concern. So I'll stop here.
Christian, maybe you can bring us into the United States.
Yeah, and I'll start by thanking Martin for the great talk. One of the things I found most interesting that I had not sort of heard before was your framing and suggestion that the Digital Single Market Directive was sort of an effort to avoid reopening InfoSoc because they didn't want to sort of touch the four existing safe harbors for transitory networks, so traditional ISPs, caching providers, hosting providers, and search. And so instead of kind of come up with like a fifth category, right, which is the online content sharing service providers. So from my perspective, one of the most interesting things to watch will be how that term is construed. I think there's a lot in the directive that suggests it should be fairly narrow. So there's the carve outs for cloud service providers, or business to business cloud service providers, cloud services that allow users to upload content for their own use. And then there's a reference in the recitals, right, to that saying something along the lines that what we're really targeting are online content sharing services that compete with other content sharing services like audio and video streaming. So you could read it really narrowly as only applying to something like YouTube, right? And so obviously I think that would be the hope. Sorry, Katie. But I don't know that that's really how it's going to play out either. So I mean, I think that's something really closely to watch. And it ties into, I think, what may happen here in the US. Already, we've seen some suggestions in recent op-eds from CEOs of big content associations that what they would like to do is sort of take the momentum from Europe and sort of bring it here to the US and try to kickstart sort of a conversation about what should qualify as a standard technical measure under Section 512I. So one of the little known provisions here in the US is 512I has a provision that says, in order to benefit from the safe harbor, you can't interfere with any standard technical measures. That term is defined in a way that requires sort of multi-industry consensus on what that standard would look like. So it's sort of been a null set up until now because there's just never been a process to determine what those standards will look like. So I think they will likely try to leverage sort of the momentum from Europe and some of the sort of quote unquote techlash that is happening here in the US to try and sort of push the the tech industry into some sort of agreement along those lines. And this ties back to the point I started with, though. One of the difficulties of that sort of process will be that we don't have this fifth category of service provider. We only have the 4 in the DMCA. So if there's some sort of an agreement about what 512C is the safe harbor for hosting providers, if there's an agreement about what a standard technical measure, what a filtering obligation is for C, it's not just going to apply to YouTube. It's also going to apply to a lot of sort of services that are much more infrastructure-like in nature. So your Amazon Web Services, potentially your other infrastructure as a service providers. And that's where I think things get really hairy, because it's one thing to have a filtering obligation that applies only to edge services. It's quite another to sort of bring those filtering obligations much closer to the center of the network. And it's also really difficult to think through how, if you're an enterprise cloud provider, you may be providing services to other enterprises who have their own sets of licenses for what they are and are not allowed to sort of make available on their networks. So I'm not really sure how like the filtering obligation could even, as a practical matter, sort of work out in that scenario. So anyways, thanks very much for your paper and for the great talk.
Probir, I wonder if I can put you on the spot a little bit, which is that, I mean, we've been talking about YouTube, and a lot of this is about video and video filtering, etc. But Facebook has tons of other copyrighted content that technically look covered by this to me. Like, how do you filter pictures? How do you filter all the various other kinds of content that go across the platform? And are there options to deal with those kind of issues, either in EU implementation or in the policy discourse more generally?
So, well, thanks, Sean. Put on the spot. And first, Professor, it was a really great presentation. Really enjoyed it. So, thanks very much. I think that is actually so whether Facebook is covered or not, the bigger question is the obligation applies to all, ostensibly, what may apply to all types of content. This is Article 17. So if you think about all different types of content, what is the state of the art for, enforcing at scale, right? So if you think about audiovisual content, think about music, but then you get into photos, text, how do you, it's one thing to have a content ID system, or Facebook, we have a what's called Rights Manager, which is a similar content recognition technology, but it only applies to audiovisual content because that's something that we have been able to iterate on for many, many years and been able to trial and error, figure out the efficacy rates and things like that. You can also, toggle the, controls so that you can decide how long of a video that, you would constitute as potentially infringing. But with a photo, I mean, there's massive expression implications that, if you think about it, does that mean a automatic blocking software for photos? I mean, we certainly don't have that for copyright purposes, because who says what's illegal, what's not? What about the application of exceptions and limitations? And context is so important for photos, right? So that's, what about comments? What about memes, GIFs? I mean, memes was a big issue in Europe, and I think that's where, who makes those decisions? How does that all work? What, in terms of the licensing structures, it's so open. So I think that's where you really get into significant issues and where you would have a lot of user expression issues. And I'm not sure any type of exceptions or limitations regime can solve it either. I think this is just something that, hopefully there'll be flexibility to allow systems to develop that can fairly accommodate all these issues. So I think that's one area that I think is really important. And I think the licensing piece as well is, how do you do authorization at scale? I mean, how do you contact every rights holder possible around the world? What if they don't want it? What do they do? I mean, this is all, what it all ends up doing is it really threatens, what, if you think about it, the open platform idea. And that's something I think certainly we've been thinking about. I know a lot of our peer companies are. I think a lot of, anyone who's interested in this area. And again, the big issue is also, what about the smaller companies as well that don't have these types of systems? So.
Can I jump?
Yeah, I want to jump in.
So I don't know, it's late enough in the evening that we didn't really do a whip around, but maybe we should have. But we do have a lot of people who are representing members who have cross-border businesses, and I think because we have academics and people representing industry, it might be useful. Here are a couple of things I want to throw on the table and get some reaction. So one is we heard that the value gap rhetoric was an important driver in this policy conversation. And I find it frustrating because my understanding of what the value gap is basically we have to negotiate in the shadow of this safe harbor, and you somehow or another are infecting what otherwise would be the fair market value of a license. And so we want you policymakers to basically change the license price by changing the liability regime. Well, you've created the market, right? The market would be a market without copyright. And what would that price be? So then you've already created copyright, that's going to affect the price. Then you create safe harbor, that's going to affect the price. Who's to say what the value gap is? You're just making explicit decisions about winners and losers at the licensing table in public policy. We should just be more explicit. And that's what this value gap, you're actually just asking the legislatures to set licensing prices. And that value gap rhetoric doesn't capture any of the value for the user, right? Where's the user's value in that equation? And Martin, I have to say, I'm a little worried about the copyright protected content and the user generated content. They're authors too, right? They have, just because they want to do something different with their copyrights than the folks who are claiming a value gap. To me, I'd love help on what that rhetorical frame is. So that's just a pitch for anybody who's battling the value gap rhetoric. It's just strip away what this really is. You just want the government to set the price for the license, and you don't like the license price I'm getting in the shadow of safe harbor. But then the question, so what are you hearing from industry, what your members, do you think this is viral? Is there something the academic community can do? Is there research that might be helpful to sort of be inputs into future policy conversations? I wanted to get that out.
Christian, I mean.
So let me add my praise to the paper. I think it's really useful. And maybe to answer Michael's question, I particularly like the framework of thinking about the directive as this triangle of three overlapping obligations of licensing, filtering, and privileging content. I think that's a useful way of thinking about how it bears on the decision-making of intermediaries. But I also think it's a useful way of thinking about how it can bleed into policymaking elsewhere. Because while I think it's unlikely that we'll see anyone cut and paste the directive in its entirety, those three concepts of obligations to filter, license, or privilege content, I think may be individually more portable than the construct as a whole. And I have concerns sort of the contagion of the directive in that sense, of parts of it, particularly on licensing and filtering, being sort of cherry picked. And to the extent that there are affirmations about the importance of limitations and exceptions and preserving user rights, that those may be lost, even though I regard those obligations in the context of the directive itself as somewhat problematic. I think the acknowledgement that this is an important interest that needs to be served by the overall system is at least in theory a positive one, but one which could be lost if the filtering mandates wind up getting cherry picked by another jurisdiction. And I think that that's one risk. I actually think there's as much risk of broad sort of collective motivated licensing mandates being adopted in other jurisdictions too, in part because of this value gap construct, which at one point I think actually had a particular meaning and described a particular outcome in licensing, but over time it's morphed into this perhaps unintentional constructive ambiguity that just means U.S. tech companies are making too much money. And that, this buzzword kind of papers over that perhaps protectionist motivation. And so that's why it hangs around, right? It can mean a lot of things to a lot of people. It's like cyber, you say it because you don't really know what it means, but everybody thinks we have a common understanding. And so
I think thinking about the directive as having those sort of three independent boundaries is a really helpful framework. And so I appreciate that as a thought tool.
You mentioned this morning that you thought maybe the link tax was the possible more viral aspect.
Yeah,
at least in the
right.
United States.
Yeah, so I don't think that framework necessarily needs to be confined to Article 17. I actually think that a lot of these, or well, since the renumbering it makes it messy, I'll just refer to the filtering mandate. But I actually think it also has some explanatory power when thinking about the ancillary copyright or the neighboring publisher's right. That there just as in the filtering context, we have a constituency that wants to ensure that its content is not on a platform, right, is not being aggregated by a news service. There are also a lot of constituencies who just want to get paid, right? And that defines different parts of the news publishing industry the same way we see different parts of the content industry. Some folks just want to not be on the platform. Other folks don't really care, but they want to get paid. And then we also have a user interest, which also must intersect with the limitations and exceptions. Right here, it's the Byrne 10.1 exception. So yeah, I like that that the framework is a thought experiment for that purpose too. And yeah, I am more concerned about contagion of ancillary copyright perhaps in the short run than the filtering obligation.
Katie, can I put you on the spot on Michael's last question, which is, I mean, you've just been in the middle of this whole firestorm, and Mike's question was kind of, is there more that academics should be doing, or there research that would help? Like, what are some of the questions that you think are lingering out there that need to be answered in order to create evidence-based policy in this area?
Thank you. Thanks, Sean and Susan, for hosting us and for the wonderful presentation. I think we're incredibly grateful. There's tremendous speed happening right now with policymakers evaluating this and having really smart, thoughtful, intellectual leaders like yourself really think through this logically. I think is incredibly helpful. We're now going to be in a sprint, in 27 or 28 countries, so your engagement is hugely important and appreciated. I think your point is right that there is a great brand of a value gap, and it's led to certain policy outcomes, but that really does need to be evaluated, and there needs to be some skepticism there. The user value is only one. So I'd say one place where I think research would be really helpful is on the economic impact of some of these measures. I think even the rights holders' own assumptions about what will happen with revenue based on the data and the business that we've seen grow, I think there is a conflict there. So like one, really simple measure would be user-generated content. So we know the tremendous societal and cultural benefits of user-generated content. We see it all the time, people with new opportunities to create and share that never existed before. But I think the economic power is really underappreciated. And the thing that I genuinely love the most about my job is when I meet creators who are powered by these different platforms and you hear their stories of what this meant. There was a really powerful piece of research in the US, but it was like probably more than 5 years ago, where it pulled venture capitalists who are investing in the startup and technology ecosystem. And they said that narrowing the safe harbors would have an impact that is greater than an economic recession. Injecting uncertainty into the framework that business models have built on would scare off an investor, right? Similarly, if you're an in-house counsel and you have this uncertainty, you will set to block, you will set to filter, if that could potentially jeopardize your entire product. So I think looking at the incentives that are embedded in this directive and what opportunities now the member states have to work within the overall structure, I think would be really important. I think for us,
that fundamental shift that you explained in the beginning of your presentation is critical, right? The shift in liability from notice to upload, terrifying. And I think really thinking through the impacts of those and are there potential ways to balance that out in implementation will be really important. In terms of the rights holder perspective, in the data that we've seen, we have global box office revenue up around the world, global music revenue up for 5 or 6 straight years. The IFPI or the RIA's own statements will say this is powered by digital and by streaming. And I can just say from YouTube, more than half of the money, so the billions and billions of dollars that we're sending out is from the UGC. So the user uploads something, it goes viral. Not only is that like fun, culturally significant, it's real money. And if you create this risk and you make that more difficult to enable on any platform, I mean, and I agree that we are more capable of handling this than potentially anyone else. We've already invested $100 million, but you know, even we are, like Prabir said, really thinking this through. But very much for local European-based platforms and emerging innovators, how they'll be able to manage this, I think, is really significant. I do think there's a lot of opportunity in transposition to clarify. The directive is vague enough, that's the downside, but potentially an opportunity. So I think the research there on kind of the actual impacts would be really significant. And I'd be really curious politically if you think this opportunity to clarify some of the exceptions would be viable in the Netherlands or somewhere else, because that's something I actually hadn't thought about. And so clarifying what's out of scope could be really helpful as well.
If I can just make one, I've pointed this out to a couple folks, but I think for, like, as a copyright nerd, it occurred to me that over the next, well, between now and June 7, 2021, we're about to see like a bunch of natural experiments as each different member state brings their law, in theory, brings their law into the compliance. Granted, some people may blow past the deadline, but in France, they're already talking about transposition. There's already been legislative processes. And so we're going to see the implementation spread out over a period of time. And that means there's an opportunity to look at how that has an impact. Granted, it will take some time to gather data on the early implementers, but the lessons that you could have empirical data on the early implementation that could help educate the later implementation. And indeed, just over time, this is probably an unprecedented, almost unprecedented opportunity to study empirically how widespread copyright modifications in a bunch of different countries affect their national economy. Right? I mean, we haven't seen anything like this probably since the 96 internet treaties, where everybody starts sort of changing their law. So I think it's actually a really interesting opportunity to do research on the subject, and also research that could, at least for the later countries, affect their decision making.
And thinking through what snapshots to take before, so that you
right, because you have to start collecting your baseline data now. Thank you.
Well, Katie was talking about the monetization that occurs, at least in the YouTube context, and others. And as Michael said, and we've heard informally from others in the EU, it's not so much that the principle; it's the price at which things happen. So, aside from the ideas that you put on the table, Professor, do you see any chance that under this construct, an informal system of monetization that's not anticipated in this construct could occur as an overlay? Not in the licensing structure that you talked about. It would have to be as part of the filtering regime, just so people could live with this rather than simply, have all of the horrible things that people very realistically talk about happening really occur.
What the legislation does is granting a very specific type of new exclusive rights that is can directly be asserted against these online content sharing service providers, which means creative industry is free to assert that right in whatever way they wish. So of course, if I don't know if there is some very good conversation between the different industry branches, and at some point there is momentum for saying, okay, how can we make this work in a way that is not explicitly in the legislation, but in some other satisfactory form that's conceivable, I guess. I mean, there are more examples out there where specific types of exclusive right in copyright are hardly ever invoked because practical level you have a satisfactory.
It seems the toleration, which is the other thing that helps the system here, seems to be off the table here. So the only other thing left is monetization of some sort.
Yeah. I mean, there are examples in the audiovisual sector already where a couple of players have said in several EU member states that the whole rights management and rights clearance has become so complex that instead of following really all the details of the legislation, they would rather seek an economic solution or a monetary solution by just saying, okay, how much money do we have to put on the table every year in order to have freedom to operate for the rest of the year in all directions that we would like to see. I guess the big challenge is really to get the different creative industry branches on the same page, because I see already now a bit of a split with the audiovisual industry rather saying, well, okay, actually we are not too happy with the final results. We would rather prefer strong enforcement instead of these licensing deals that also put us under pressure to offer some broad licensing scheme. The music industry seems quite content with the result that has now been achieved. So for me, this comes a bit as a surprise, because I mean, from a legal doctrinal perspective, this really is an earthquake. So when you now listen to representatives of the audiovisual industry saying, we are not so sure, perhaps we would be better off without this, because then we could have stronger enforcement and so on. Yeah, I don't see this happening very easily, but
it's not an optimistic question at my point.
I have a quick question. So as you've mentioned, we're now entering this transposition phase, and I guess the question is how much creativity can there be? In particular, I just wondered whether let's say the Netherlands or Holland or Poland, for example, their transposition wanted to say, well, if a user, especially in light of the recital that you put up on the screen of, that this is not supposed to have any impact on exceptions and limitations, that if a user certifies, or the uploader certifies that this content is not infringing, or that it's everything that is used is being used under an exception, that then that's an alternative to the licensing or the filtering. I mean, does that, and then of course, users are just going to click on the box, they'll just certify, right? Just anything to get it up. But can, is there enough flexibility perhaps in the directive to allow a country to adopt something like that, to say, yeah, that's kosher, and would the Court of Justice then say, yeah, okay, that is consistent, or is that just too?
Well, I think we must not be too optimistic here, because member states have made quite difficult times really with experiments during the implementation of Directive. So there are examples from the past. For instance, the Netherlands has a very broad implementation of private copying. So under Dutch law for quite a while, the understanding was that even downloads from illegal sources, so you download from the Pirate Bay, for instance, then that would still fall under the private copying exception. But there was a practical motivation for that. The Dutch legislator said, well, in that way, it falls under private copying, so the remuneration paid also covers the illegal downloads.
which is better than not seeing any money for this at all. So it was very practical. The whole thing went up to the Court of Justice, and the Court of Justice said, no, this is against the three-step test. The Dutch legislation has been excessive, which means that the Dutch state had to pay damages for all the private copying acts that had taken place during that time. So that was a very costly exercise, basically. So examples like this have led to a situation where member states have a tendency of following the text of directives and so on relatively closely. So when I hear that we won't see a verbatim transposition of the text of the directive, I agree, because I think there are too many open questions. So member states have to take for certain decisions to clarify the thing, to make it work. But I don't think the appetite for big experiments is really there. If we find that appetite, then it's still the member states who have rejected the thing. So Poland, the Netherlands, Italy, there are a couple of member states who voted against. Yeah, the problem is that if finally the Court of Justice says your implementation of the directive was not correct, then this has retroactive effect, because we are expecting that you know the law as it really is, even before the Court of Justice clarifies the law. So you don't get away by saying before the Court of Justice ruled on the thing, we could not know better. So this makes the whole implementation exercise one that I would expect relatively close to the text. And I heard that well, practically things like broadening exceptions, limitations, and so on, this is something that does not fly easily, put it mildly, in the EU. By contrast, models based on licensing, letting people sit around the table, negotiate fair terms, and this is something that everybody wants to hear. And we had a big debate on licenses for Europe for years and years, where several roundtables were brought together and so on. And the result was almost zero. So we don't see these licenses for Europe. We get this new legislation, and the primary model is licensing. So I mean, this is how much this is ingrained in the policy decision making. So I see your point, but I'm not too optimistic.
So I believe there's still a bit of a reception outside.
There's
Is
quite a
that
bit of a
right? And
reception,
we should
yes.
probably hit it before they take it away. And I believe the Canadians are recruiting people to go root for the Raptors for another hour, and we need to get primed for that. So thank you, everybody, for coming. We have some time to kind of take it into informal conversations outside. And thank you, Susan, for hosting us.
My pleasure.
Another.